Couple of things here probably Extinction Rebellion should know about. There's a couple of laws for enclosures. This is contemporary with Charles II, George I. Looks like quite a way through, really. So it says that persons breaking any hedge, pales, rails, or fences, etc., shall make recompense or be committed. So we know that the word committed definitely means, prosecuted and convicted. But what's interesting here is it's got a differentiation between recompense or committed. So there's a differentiation there, that there's something else. Recompense, it just means that they should fix it or repair it rather than being prosecuted or imprisoned. I'm wondering if with Extinction Rebellion, when it says, it's the right to petition and all prosecutions and commitments are illegal, and the claim of right supports that you can't be imprisoned, I'm starting to wonder if you can just be made to make recompense, which just means to fix it or whatever, or to repair it without even actually being prosecuted or committed. Like in civil disputes, made to pay money if it's dealt with in a civil matter or not criminally. But I don't think that you can be prosecuted by the courts anyway. And then it also says there's quite a few citations for that as well. It looks like that law it's got multiple citations. Persons breaking down any of the enclosures, etc., in the New Forest may be fined, committed. In the New Forest. And that's from... Is that William? Now here it says that if one actually acquits themselves of a crime, the person who called them out on the crime has to face imprisonment. That's an Edward I one, so that's quite old. That's how they did it, though. That's in the 1300s. I think that's before the Justices of the Peace Act as well. So actually, if someone called you out on a crime and you actually acquitted yourself, then they had to get punished. But anyway, so this enclosures, what's interesting here is it's actually got, we're interested in the subject of riots or public demonstrations or just, disturbing the peace. All the things that are discussed in that Professor Karen Bowie's paper about petitioning and activities around it. So here it's suggesting that for things like that, breaking down fences or rails or pales or anything, that type of thing that might actually happen in a demonstration or something, that there's a differentiation between recompense and being committed. So in the 1688 Bill of Rights, when they say all prosecutions are illegal for, when you're actually petitioning and you've got a lot of people signed up to it and it's meant to be a suit or an action, it might cover you for that. This might be good evidence that, maybe you might be made to fix it or whatever, or do something, but not be prosecuted or committed. Now, I've actually found the indemnity section as well, believe it or not. There's two bits on indemnity here. It says, none to be impeached for felonies or trespasses in the prosecution of dispensers. So I checked up the word dispensers, and there's two spellings, dispensers and dispensers, but there's both variations. There was a family called the dispensers, that there was a small war with earlier on, but I think that it is referring to... It actually does mean in pursuit for prosecution, this, I think. I think this means that for when you're prosecuting people. I think this is the basis of the police, none to be impeached for felonies or trespasses in the prosecution of dispensers. Now, this was repealed, but then revived, and then the repeal made void. But this is up to Edward III, this. And Edward III... Edward III's like 1300, so, I mean, it's not that early, but... I think this is around... So Edward III, that is around the time of your very early Justices of the Peace Act. So I'm guessing that if that is this Edward II there, there's two citations of Edward II, and then there's a citation of Edward III. So that is around the time of those. It's quite a well-known act. It's quite a well-researched act, like the early Justices of the Peace Acts, when they start getting people selected in the local areas to be, justices. And then also, like you got the hue and cry and and you get the jurats that people elect and so forth. So that, I think that is if that is from Edward III and Edward II, indemnity, under indemnity laws, I think that sets you up pretty much for if you're in the pursuit of criminals. Particularly, that would probably under hue and cry as well, because it had to be made an official declaration, and then they had to have more than two witnesses, and then if the public the 100 had to pursue the criminal and capture him, or they actually got fined. Therefore, I think that they were allowed to... this covers them for policing, basically. So that really looks like it could be... This could be like your very, very early founding legal clause or principle underneath the whole of pursuit of the criminals, which is pretty much what I was using myself when I'm investigating legal road signage and pursuing that. So it's founded, actually... It's founded in that's quite early on, that Edward the First and Second. That's really, really early on. And then we've got obligations and compulsion during the late rumour and riots, annulled. So it's saying that when there's riots on here, saying that obligations and compulsions, things that you have to... That basically means obligations and compulsions is that things that you have to do without really any choice, if, defending your property or acting to defend other people during rumours and riots, that's annulled. Indemnity for those who armed against traitors. So if you're taking arms against, traitors, then you've got indemnity. Robbers, outragers, and in the commotion. Maybe if there are a large number of people doing petitions and they're causing trouble, maybe that covers... Maybe that's riots and rumours. Obligations. Maybe if there's large numbers of people kicking off, then... maybe you've got indemnity and commotions then in that case, under this basis and principle. It's just a legal basis. I'm not saying it's still in effect. No one's saying that these are still in effect, but it's like setting out examples of early legal basis of which it's founded on and modelled around, isn't it? That would mean that if something kicked off, like look at those in France, look at all those riots in France, if people are doing certain things. You see, if people are doing a petition and they're using the right to petition and they've got immunities or so forth, and other people get tied up in it and caught up in it, really, if the police are there and people are, they've got to respond or react to it, events happen. Now, I know there are certain laws against, having a standing army, rebellions and so forth. If you try, like legit, if people are seriously, taking over governments. But according to this, it seems that if you get caught up in something that, like some incident or event arises and there's people kicking off, seems to me like the police shouldn't. Really, it's not your fault, is it, if you've got to respond to something? But what you get is the police. I think the police. Actually, this is interesting that Tooting demonstration the other day. When apparently the police turned up and then they were loitering around and then they started arresting. They arrested a few people, but I think they went around and told everyone in the shops to stay in the shops. But if other members of the public had been, caught up in it, really, they might have ended up getting arrested just for being there. According to this, you shouldn't get arrested just for being there or having to respond. But then again, people are using the right to petition, and then there's people subscribed to it, witnesses signed up to it, and oath. This is what we're looking at for the basis of dispensing. Those who assisted the king, H, against the king, R, or his adherents. So obviously people who are supporting one king versus another are getting indemnity. You see, you've got the act of indemnity. So that, you see, that the basis of that there, those who are in allegiance and, with the king and so forth, in conflict, those who stand, this is what happened after the Civil War, isn't it? Those who, you see, when Cromwell won, then everyone who supported Cromwell got cleared, and those who opposed him got prosecuted. But then the opposite happened when Charles got back in, and they dug up Cromwell, and they did all the other people the opposite way around. And then you've got that Act of Grace, and then you've also got the Act of Indemnity in 1688, which I didn't even know of, that goes with the Bill of Rights, but they exempted people out of it. I think he exempted out of it certain high-ranking people, lords and barons, who they considered not worthy of being in the Act of Indemnity. They exempted them out of it, and I think they prosecuted them in the Tower. And then this is a continuation of that, which is indemnity of those who repressed the late insurrection, reprised. Repressed. Indemnity for those who repressed the late insurrection. So for trying to quell it or quash it. So you clearly get indemnities if you are doing something on behalf of the nation or country. Those who assisted the king against the Duke of Gloucester. And then offences during the Troubles, Charles II. Persons acting in bringing in their majesties, William and Mary. Of persons acting in bringing in their majesties, William and Mary. I think that's the act. William and Mary. That is the act of indemnity. So that's tied into that. Of such as acted in defence of the kingdom against the invasion. But what about the invasion in 1066? That's kind of joke, isn't it? Well, that's a William and Mary one as well. Of such who acted in defence of the kingdom against the invasion. For anything done in order to suppress the late rebellion. Is that George I? Of things done in defence of the government and during continuance of the rebellion. For other matters, see pardons and parliament. Well, the thing is, this is kind of ridiculous when you've got the right to, get evidence, possibly with a grievance against the government. The ridiculous thing is that most of the petitioning, which you've got the right to do and the privilege and supposedly immunity or protection for doing, is meant to be because you've got a complaint against the government or an issue with them, either a grievance, a complaint, a trouble, or that we want the law changing or something. But I think the whole point is this. They've made that process for you to use that process to go about doing it, right? Not actually overthrowing the government or removing the government unless by, electoral means or whatever. But we've got to the point now where I've this is what the point what I'm up to. Extinction Rebellion is a little bit different, I think. because they're not trying to overthrow the government. They're complaining about all these companies and businesses doing, like, harmful environmental projects and things, and they're all under Companies House anyway. It's just actually trying to get policies changed and manufacturing and industry and so forth changed for the environment through public demonstrations. I think with this, the problem I've got at the moment really comes to a head on this, really, which is that like with the illegal speed cameras and signs, the problem is they've put the Crown logo, the Crown emblem on them all. So the problem is that when you're calling it out for being corrupt and not lawfully operated according to law, and you report it, it's going to make the government look bad at large, wide. And there are Privy Council clauses for not making the king look bad, even in image or style or whatever, and that's problematic. Even if you're petitioning the king directly with grievances, but there are lots of things the king can't do, though. This is the problem. That we've got 1700 Act of Settlement, not allowed to give up rights away and so forth, and the king's under oath for that, and the king's actually under certain oaths as well that we've got to hold them to. It seems that the right to petition, obviously, if it's the right to petition the king and all prosecutions and commitments are illegal, surely it means that the king can't be prosecuted either. You can put a grievance to him and complain, but he can't be prosecuted or committed. But I don't think you can either, surely. So it's almost like a standoff, isn't it, really? It's like a touche moment. It's almost like touche. At the end of the day, it seems like it comes down to diplomatic negotiations or whatever our evidence. But I don't see what... It seems that the House of Parliament or the law, you can petition the House of Commons or Parliament, but it seems the Privy Council seem to be a bit of a spare prick in a brothel at the moment. They're a bit useless. When they're in charge of the judicial conduct over the judges and justices not getting his rights granted, it seems rather ridiculous to me. I mean, what the point is that they're meant to be there to uphold the law and justice. If the king's above the law, and anything that you do is, the problem is that it goes. The issue is with laws that it doesn't really matter as long as if you are going against what is written, then you're doing wrong, and if you're not, then you're not. The problem comes down to conscience. The laws are supposedly meant to be based on morals and human right and wrong. A lot of the laws, though, are basically just what the government have made up. And then you've got the whole judgment of the peers, whereby, you can get acquitted, apparently, on the opinion of your peers, if they don't agree with the law, or if they don't think the law should apply, or whatever, or if they just want to exercise forgiveness. But that doesn't apply so forth if you raise the matter upwards to the Parliament or Lords. And if the Lords cannot exercise any conscience when it comes to the king, then it seems rather ridiculous. There's also some really interesting laws in here that, if they're still in effect, like making invasions illegal. But if you at that point, if you can backdate them and use that law, it writes off the whole thing. But anyway, so the thing is, if you use the right to petition process and you form a writ and an oath with evidence and you submit it in grievance and complaint, and then you go about what you need to do for that, gathering evidence, or whether it might cause misdemeanors, getting evidence, trespassing or whatever, but it's not in jurisdiction of the normal local courts, this is under Parliament jurisdiction, then it is supposed to be a lawful due process. And you're doing it under the laws of England, and if you're doing something because some things are wrong and they need to be put in right, if something's been done unlawfully or illegally, then really you are acting in the interests of the kingdom. So that is really why, there's so many different indemnities now through here, right? Just for doing things on behalf of the nation or country. There is a. It's not, and in the Crown Prosecution Service use assisting offenders, which is from the Criminal Law Act 1967. I think that assisting offenders in the 1967 Criminal Law Act, in Section 3 or 4, whichever it is, then that really comes all the way back to here, none to be impeached of felonies and trespassers in the prosecution of dispensing. So if that is what it is, and if I haven't got that wrong, but seeing on the date of it, which is, we're looking at like 1300s and before, I think that goes with the let me search for which. There's always one Justices of the Peace Act which shows up, which is quite an old one, 1361. I don't think there's a 1361. Justice of the Peace Act 1361. I think that is one of the earliest ones. So this will be before that. Justices of the Peace Act 1361. And this is like Edward the First is 1272, and then Edward the Third is 1327 to 1377. So that actually is kind of like, that's around the time of those Justices of the Peace Acts. I don't think that getting prosecuted, if you're using the right to petition and you've got reasonable excuses or so forth, I don't think that you can be committed or prosecuted. You might be able to be made to give recompense. I'm wondering if prosecutions and commitments being committed to prison, and prisoning is illegal, like in the claim of right, I'm starting to wonder if they can bring a civil action against a complaint to the government, for payment or whatever, like in recompense, or just getting you to fix it, like Gail Bradbrook with that window at Horseferry Road. But saying that, they didn't have insurance back then either, third party insurance liabilities and so forth. I know they've got to pay. Company, you've got to have insurance now. People have insurance. Those insurance companies make a lot of money. Like, what's the point in it? You might ask, what is the point in the insurance? Now, they might lose deposits and so forth. I mean, maybe you could make them pay the deposit on the insurance, something like that. But I think that if it's claimed in under an action when people are sworn in on these oaths in the petitions officially, and it's like, your peers have judged that these actions are requisite or required for the actions, I don't think that you criminally regarded as a criminal. I don't think that it regards you as a criminal, but I think that, if it's covered by insurance, but what if it's something rare that can't be replaced? You know what I mean? That then you're starting to, get into, conflicting territories, like irreplaceable things. But how would you fix that anyway? Even if you were a criminal and you broke something that was irreplaceable, you're not going to be able to replace it. Even if you put them in prison, or even if you put them in prison or fine them and prosecute it, it's still not going to get it back. There's all kinds of indemnities going on here, though. Mainly when it comes down to national interests and allegiance and so forth. How about on London Bridge when that was it Stephen Gallant or whatever he was called, apprehended that that's got to have been a setup though. That he was in the right place at the right time, out of prison, and then he captured that that bomber or whatever, that terrorist, and then he got a pardon. So I'll put these up anyway. I'm going to put these up. Because this is like, it helps to show that maybe breaking fences down and those kind of things that are kind of like things that might happen in a riot or a demonstration, windows, fences, that kind of thing. You see, all those what fall under the Criminal Damage Act, if you've got a right, privilege or interest, that's like things that will fall under the Criminal Damage Act, right, privilege and interest. But even then, you've got the Town and Country Planning Act, which actually specifically and explicitly describes all of the surface damage to things as defacement, and you're exempted out of that anyway under the Class F, and even for any damages or danger that's left behind after. On that legal basis and principle, you're really looking at that applying to the Criminal Damage Act in the same way, which would fall under this basis as well. And on that, I mean, it's not for the normal courts of the jurisdictions to get involved in matters that are being brought to the Parliament anyway. And then I suppose we get into Lord Hanningfield, why I think they're calling his misdemeanors out under Parliament, but there were questions around that with his privilege that apparently he could have been prosecuted, but he still got indemnity. Maybe that means that the protesters can be taken to civil court, but they don't go to prison. If it's the same basis as what I think for Hanningfield should have been the case with some of that legislation, So anyway.